All right. Good morning, everyone. My name is Noelle Hicks. Welcome to Pitfalls of the Collection Process. Today, we're going to go over some of the issues that we see come up as we're kind of navigating through the collection process. And this is a bit of a deviation from what we typically do. Normally, we will talk a little bit about what the collection process looks like, or even what the deed restriction enforcement process looks like from both the association and the attorney perspective. And today we're going to get into a couple of the pitfalls that we see or ways that we can kind of get tripped up when we're going through that process. And we thought it was a really good idea to kind of go over some of these things. So it's things for us to look out for. Obviously, if we have that information, it'll be a little bit easier for us to identify them. So we'll start out with our disclaimer, the same disclaimer that you always see. This information today is provided as the law exists as of May 20th. We are not doing this for legal advice, but solely for legal information. So if there's anything that comes up that you might have questions on, consult us or the association's attorney. I do want to warn you guys, I have had some of the strongest coffee that I've ever had in my life this morning. So if I am talking fast, that is why. I'll try to slow it down a little bit. Here is our agenda for today. So first, we're going to go over some issues that come up with notice and the notice requirements from the Texas Property Code. These are a lot of things that you'll obviously see them quite a bit in your everyday day-to-day work because we're always kind of sending out those notices. We'll give you those from management, association perspective, and then also from the attorney perspective. We will talk about some pitfalls that are associated with board inaction, which kind of goes hand in hand with the statute of limitations. We'll also talk about some of the issues that come up with partial payments. And then finally, we'll get into bankruptcy. And I think that's probably going to be one of the best topics, honestly, because there's a lot of issues that come up when it comes to bankruptcies and homeowners filing bankruptcy and the different stages at which they could file. So it's important for us to have that information so that we can, do the best job that we can. So first, we're going to go ahead and get into notice. Now, all of us are familiar with the 209 notice that is required by the Texas Property Code. The section that can be referenced for that is section 209.006. A lot of you probably have the property code books that we publish, and if not, then they are available on our website as well. But you can go and reference section 209.006 to ensure, one, that you're sending out a proper 209 notice, that it has all of the different requirements. But also you'll see in the property code that 206, 209.006, 209.007, and a couple of the other sections of the property code are pretty closely intertwined. And so it's important to kind of know exactly what each of these state. So with 209.006, this is the notice that the association itself or even their management company has to send out before it does certain things, before it can suspend an owner's right to use the common area, before it files a lawsuit. And of course, there are certain exceptions for that, right? So it says before you file a lawsuit, except for collection of assessments or foreclosure. Also, before the association can charge an owner for property damage, or before it can levy a fine for any violation of the restrictions or rules of the association. The association absolutely has to provide this owner with notice. Now, we're not talking about a courtesy notice. Quite often, you'll see in the policies that the association has a collection policy, for example. It will lay out certain notices that the association will send over to a homeowner who is in default of the paying for their maintenance fees or their annual assessments. Well, the association can send out courtesy notices, which we encourage them to go ahead and do, because at the end of the day, when we're going before a court, the court likes to see that the association has done everything that it can to reach out to the homeowner. So these are not courtesy notices that we're talking about. Rather, this is a requirement by the property code. And it's very important that this notice gets sent out to a homeowner to let them know of their delinquency. And I will talk a little bit about why that's so important, aside from the fact that it's required by the property code. So keep in mind that this kind of notice, and we're not talking about just a courtesy notice, this is something that absolutely must be sent out by the association to a homeowner to let them know that they have a delinquency. And also, when it comes to deed restriction enforcement, this notice must be sent out as well to let the homeowner know, hey, you're going to get a fine if you don't go ahead and cure this violation, and so on and so forth. Another requirement from the property code is that these notices that I'm talking about are a 209 letter must be sent out by certified mail. And it's really important that this actually gets it sent out by certified mail. I know that sometimes that can be burdensome financially for an association to send out certified mail return receipt request 209 letters, but it is a requirement from the property code. And in addition to some of the requirements that I mentioned on the previous slide, there are other things that are required to actually go into this 209 letter, right? So the notice has to describe the violation or property damage that's the basis for the suspension, or the charge or the fine, and needs to actually state whatever amount is due to the association from the owner. It also needs to let the owner know that they have some amount of time that they can cure the violation to avoid the fine or the suspension, unless, of course, this violation is a threat to public safety or health. And unless, of course, the owner was given notice of the violation or an opportunity to cure it within 6 months preceding that time period. Now, of course, today we're talking about pitfalls, and some of the pitfalls that you can see when it comes to these kinds of notices are failure to send that notice by certified mail, failure to accurately describe what the reason why they're getting that notice actually is, failure to let them know that they have an opportunity to cure. Generally, we would say that that should be about 30 days. So there are, various things. If we're not going specifically according to what the property code actually tells us, this can actually be a pitfall. And I know that this is something that usually comes up a lot more with those communities that do not have management representation. If they're self-managed, then they might not have all of the information that they need about what's required by these notices. So those are a couple of pitfalls we can see there. A couple of other things that absolutely must go into these notices is that the homeowner can request a hearing. So I mentioned earlier that there is some sort of connection between 209.006 of the property code and 209.007. That's the section of the code that actually allows a homeowner to request a hearing on or before the 30th day that notice was mailed to the owner. So if that provision is not included in that 209 letter, then that is going to be another pitfall, right? Another requirement is that we must notify homeowners that they might have some relief under the Service Member Civil Relief Act. And, if that homeowner is actually serving in the military or on active military duty. So these are all requirements. They absolutely must be contained in that 209 letter. If they're not, then it's not a valid 209 letter, and that's just something for us to keep in mind as far as our pitfalls are concerned. Now, I mentioned earlier again that there is another really good reason why we want to make sure that we are following the Texas Property Code very specifically as far as what goes into our 209 letters. And one of those reasons is Section 209.008 of the Property Code, which was related to attorney's fees. So this is actually really important, especially if there is, and eventually this kind of happens, right? There are some homeowners who absolutely refuse to respond to the notices that the management company is sending out or that the association is sending out. And eventually those matters get referred over to an attorney, whether that be our firm or whoever represents the association. And in order for the association to actually seek reimbursement of any attorney's fees that are expended for getting the homeowner to abide by the restrictions, then that 209 letter absolutely must go out. So the property code is pretty specific in this, and it says the association can collect attorney's fees and costs for enforcing the governing documents if written notice is provided, and especially if that violation or continues, right? And when we're talking about violations, we're not just talking about a deed restriction violation, but keeping in mind that failure to pay the assessments is also a violation of the restrictions, right? The property code is very specific again in the fact that it says that an owner is not liable for attorney's fees if those attorney's fees are incurred before the conclusion of a hearing under Section 209.007. And obviously that means that the association has to actually notify a homeowner that they have the right to request a hearing under Section 209.007. And again, that's where 209.006 comes in, which requires that 209 letter that we've been talking about. Now, of course, if the owner doesn't timely request a hearing, again, that doesn't really matter at this point. We got to make sure that the owner at least knows that they have the option to do that. And that comes within that 209 letter that we're going to send. And if the owner, does not actually request or does not actually show up for a hearing that they've requested, it doesn't matter. The association still has to hold that hearing if the owner has requested it. But again, the attorney's fees that are accruing, if that letter is not sent out, the association can't seek reimbursement of them. And if the attorney's fees don't come until after the time period where the homeowner has been given to request a hearing and actually have that hearing, then again, those attorney's fees cannot be reimbursed. So we got to make sure that we're following the property code very specifically. And that's kind of the point of the reason why we do webinars like this, so that we can provide to you what the property code actually says. And then you guys can kind of follow suit, right? Make sure that the association is following these rules very specifically. These are some things that we probably would have in our collection policies if the association has one. But again, these little reminders are good for us to kind of avoid those pitfalls. So just kind of to recap on that, we want to make sure that 209 letter goes out. It gives the homeowner all of the different items that it can request, gives it all of the information that it needs according to the property code, so that eventually, if this matter is turned over to an association or association attorney or referred to the association's attorney, then we can actually seek reimbursement of attorney's fees. All right, so now there are a couple of other notice requirements that I wanted to point out just so that we're clear. And this one is kind of more for the association attorney, but this is absolutely a prerequisite to foreclosure that is prescribed by section 209.0091 of the property code. And it basically states that if there is a inferior or junior lien holder that has filed a deed of trust in the real property records, then the association has to send notice to that junior lien holder, right? To let them know that there's a possibility of foreclosure on that property. That lien holder notice, the requirement in the statute is a 61-day opportunity to cure for the lien holder. And this also must be sent by certified mail to the lien holder's address, whatever address that's contained on that deed of trust that's been filed in the real property records. Again, this is more a requirement for the association attorney after we've gotten to the stage where we've sent all of the letters that we send internally, which I'll talk to you a little bit about later on. We also kind of do a search in the real property records, a title search, to make sure that we have all of the information correct, right? First, we want to make sure we have the proper homeowner. And then another thing that we're looking for is if there are inferior lien holders that have any deed of trust filed. Now, there might be inferior lien holders that don't have deeds of trust filed. That doesn't fall within this provision of the property code. So there has to be a deed of trust that's actually been filed in the real property records for this to be triggered. Now, internally here, as far as attorney notices are concerned, there is a requirement under Regulation F of the FDCPA that requires attorneys to send out certain notices that would let a homeowner know exactly how much money that they were seeking repayment of, or that they are delinquent in. And it also gives them, certain other information, lets them know where this amount can be paid, certain other things, right? And some of the ones that we kind of want to point it out, according to Regulation F, is that one, as I mentioned, it outlines the amount of debt that's owed. It also provides instructions to dispute the debt. So in addition to letting the homeowner know where they can pay it, it also has to allow the homeowner to know how they can dispute it. This was intended to be a protection for consumers from debt collectors. And so one of the reasons why this is pertinent to us is because the association attorney is generally falling under that definition of a debt collector under the FDCPA. So this is one of the steps that we have to take pretty much as soon as that account is referred over to our office. We do certain checks and balances, and then we go ahead and send that Regulation F notice out as well. Now, whereas a 209 letter generally would give a homeowner 45 days to remit payment, a Regulation F letter allows 40 days for a homeowner to remit payment or enter into a payment plan. So this is just to kind of let you know, these are some of the requirements that we have internally, but also it can be a pitfall if that letter doesn't go out. Obviously, there are certain checks and balances, as I mentioned, to make sure that we are properly sending out the notices that we need to every homeowner. And obviously sending all of the, making sure all of the requirements are met as well with those notices. Now, there's one final notice that I wanted to mention, and this one is with regards to assessment lien filing. Now, this is a newer requirement. Generally, associations were allowed to go ahead and just file a lien in the real property records that kind of put everyone on notice, or all people that might have been related to the real estate transaction of a certain property, putting them on notice that there was a lien that had been created by the declaration, and that was that lien that was created by the declaration, made it so that this homeowner was personally obligated to pay those assessments, right? Well, the property code has been amended as of 2023 in section 209.0094 that sets out certain notice requirements for prior to the time when the association can actually file an assessment lien in the real property record. So it sets out a couple of notices, right? The first notice has to be sent either by first-class mail to the property owner's last known mailing address, or it has to be emailed to whatever email address that has been provided to the association by the property owner. Now, this actually contemplates that the owner has actually updated the association with their contact information. If that's not available, then go ahead and send it by first-class mail. But then there's also a second notice that has to be sent out. So this provision allows for this second notice to be sent out by certified mail. It obviously can't be sent any earlier than 30 days before that first notice was sent. So that actually means that the first notice is a 30-day notice. And then the assessment lien itself can't be filed before 90 days after the second notice was sent. So that adds quite a bit of time onto the collection process if the association actually files those assessment liens in the real property records. If not, then that doesn't relate to your specific association, but this is just something to keep in mind if the association does file assessment liens. Now, also, generally it's not required unless the governing documents actually put that requirement in place. But keep in mind that the declaration itself, once it was recorded, it creates the lien on all of the properties in the subdivision. All right, so here, just kind of wrap up the notice pitfalls section of our conversation today. There could be some misunderstandings of the legal process, and obviously what I gave you just now was kind of a high-level view of all of the things that we need to know about notice as far as the collection process is concerned. Keeping in mind, courtesy notices do not take place of the required 209 notices that I just mentioned. And the board actually has to vote to make sure to proceed with those collection actions. And I'll talk about that in just a second. Any failure to actually take action in a reasonable period of time could result in the association having to kind of start over from the beginning with the collection process. And whether that means starting over with the courtesy notices or going straight to a 209 letter, that's up to the board's discretion. But it is important to know that, the association can't really fail to act, because it kind of adds more time and can disrupt the association's ability to actually enforce the restrictions. And I'll tell you a quick little story about that. I've been dealing with an association recently who had prior counsel and had gone through a couple of management changes. And the last time that they had probably sent out a 209 notice was several years prior to today. Not only that, but they weren't getting a lot of action from their prior representation, their prior legal representation. And so they are essentially having to start over with the entire process, which might result in some of the amounts that they're seeking to be barred from collection by the statute of limitations. And so it's actually really important that we follow those processes that we have kind of, to a T as much as possible, because it prevents kind of the chaos of trying to figure out, well, when's the last time we sent out a 209 notice? How much is actually owed on the account? Those kinds of things. And also kind of keep in mind too, this helps with keeping track of the homeowner's accounts, right? If it's been, you have terrible files from a prior management company, or, the association was self-managed before you kind of stepped in to assist with the collection process, then that could be quite the undertaking of kind of trying to figure out what account histories look like. But if you are keeping up to date with every year, making sure that, you are sending out all of the invoices or the notices that the assessments are due on a certain date, letting homeowners know when those amounts would become delinquent, letting them know what their options are, and then explaining to them or letting them know what the collection process would look like, then that will kind of help you stay on track as well. All right, so let's go into board in action. You guys have probably seen this graphic from our firm several times, but this is an outline of all of the different actions that the association or the board must take during an open board meeting. And you can see that's highlighted that initiation of foreclosure actions is one of those items. So if the association intends on initiating a foreclosure action, which arguably that could be either sending it over to initiate just the demand letter process, or it could actually mean right before we get to the process of filing a lawsuit. But regardless, it means that the association has to actually consider this in an open board meeting. So let's get into that a little bit more, because what does that actually mean? A lot of times we have questions about, does that mean actually in an open board meeting in front of other homeowners, or are we talking about during executive session? What exactly do we mean? Well, first, let's look at the section of the property code that actually makes this requirement. So the prior graphic is a reflection of section 209.0051, which requires open board meetings. And this basically just says that a board can't, unless it's done in an open meeting for which prior notice was given to owners, consider or vote on initiation of foreclosure actions, right? So always keep in mind that the board must absolutely discuss and vote on initiation of foreclosure actions in an open board meeting. Now, we get the question a lot about whether or not this can be done in executive session. Yes, it may be considered in an executive session, keeping in mind that after you are adjourn your executive session and reconvene into your open board meeting, that whatever you've discussed during the executive session has to be summarized orally and then placed in the meeting minutes. But this should be done in general terms. So we don't want to breach the privacy of any individual owners. We don't want to violate any privilege. And when we're talking about privilege, we might be talking about like attorney-client privilege. And we also don't want to disclose any information that should remain confidential at the request of the affected parties. So what this means is essentially you can go into executive session and discuss in detail with homeowner information, specifics about the amounts that are due, that sort of thing in your executive session. But when you adjourn your executive session and reconvene into the open session, then you want to make a general motion. And this is our recommendation, make a general motion that basically states all of the information that we discuss, or all of the accounts that we discuss during executive session will be referred over to the association's attorney for collection efforts, something to that effect, so that you're not breaching the privacy of individual owners or letting other homeowners know who might be delinquent or who has a violation on their property, because that's actually something that is prevented by the property code. And then again, you don't want to violate any privilege, because there might be a situation where you're discussing an already ongoing litigation matter in that executive session as well. So these are just some things to keep in mind when you're dealing with open board meetings and whether or not you want to initiate those foreclosure proceedings. Now, here are some pitfalls that we can, kind of highlight about board inaction. Failure to approve enforcement action in open session. So if the board fails to do that, then that might be a violation of the Texas Property Code. And so instead of going ahead and referring the matters over to the attorney, you need to wait until the next open board meeting to actually consider and vote on them, as it was mentioned in section 209.0051 on the previous slide. And if that happens, if you're sending over matters without actually approving them during an open board meeting, that actually could affect the association's ability to enforce the restrictions if we actually get to the lawsuit stage. Because I have seen time and time again, when there is a lawsuit going on and there's an attorney on the other side and they've requested a discovery, the meeting minutes or something to that effect that actually show where the board considered and voted on transferring this matter over to the association's attorney. If we're not able to provide that, that actually creates a problem in litigation. And it could actually show that the association did not perform all of the conditions precedent that it was supposed to before we actually reach the stage of litigation. So got to make sure that we are doing that. And then also another issue that could come up with the failure to take action is the statute of limitations. As we all know, the statute of limitations for delinquent assessments is 4 years. And if the association is failing to take action on enforcement, then it could lose some of the assessments that it's owed to that statute of limitations. So keep in mind that we want to keep, go ahead and make those decisions as they're coming up so that we're not losing out on enforcement ability. And also, that could bring a defense when we're in the litigation stage, right? In addition to the statute of limitations defense that can be raised in litigation, an attorney could raise a defense of waiver, that the association waived its right to actually enforce the restrictions because it took so long to take action. So those are some pitfalls that we can see when it comes to board inaction. Now let's talk about partial payments, because this is actually a pain point for a lot of us, I think. And there are a lot of issues that can come up with partial payments when a homeowner attempts to make a partial payment. And most of the time I see this when a homeowner has several different charges on their account. Maybe they have 2 years worth of assessments, but then there is also interest and late fees and maybe other administrative costs. The homeowner will go in and make payment that amounts only to the assessments, because it might know that the association will have a harder time in litigation or with enforcement if there are no assessments actually due on the account. So we have to make good decisions about whether or not we will accept partial payments. One of the complications that we can see with that, especially in the litigation context, is the defense that's called accord and satisfaction. So basically this happens when the parties agree to discharge a delinquency or the existing obligation in a manner other than full payment, or whatever the terms of the original contract are. And in this context, the original contract is the declaration, right? Or the homeowner's purchasing a property in the association. So when a homeowner purchases a property, they basically agree to that personal obligation to pay assessments. And generally the declaration will say something like assessments, and if it becomes delinquent, late charges, interest, attorney's fees, costs, so on and so forth. So if the association determines that it would accept partial payment, then a homeowner can come in and say, well, I have paid the association less than the amount that was actually due, but this brings up the defense of accord and satisfaction. So this can be done either accidentally on purpose, and I will get into a couple of ways on how that can come up, but it's something that we need to look at. If the owner is attempting to pay something that's less than what the total amount is, then there either needs to be a payment agreement in place, or I would recommend not actually accepting the payment. But the association should also have a provision in its collection policy that talks about what would happen if our owner submits partial payments. So what do you do if you get a partial payment, right? You get a check, and let's say that the total amount owed is actually $10,000, but that's only comprised of like $2,000 worth of assessments. Now, of course, that $10,000 could be fines for a deed restriction violation or whatever the case may be. If the association accepts that $2,000, what happens? Now, you have to look at a couple of different things, and this is probably going to be something that's left up to the board's discretion, because let's change that scenario a little bit. And if the total amount that's owed is $10,000, but the owner is making an $8,000 payment, well, that is a substantial payment towards the balance that's actually owed. So there's a lot of considerations that need to be taken into account here, right? What's the timing of the payment? What's the amount of the shortfall, right? Are we talking $8,000 or are we talking $2,000? And then you really need to take a look at the application of payment statute so that we can kind of conceptualize what exactly we're talking about here. And on one of the next slides, I'll show you what the application or priority of payment statute actually says. And that will help us to figure out generally whether or not we're going to accept a payment, right? And I mentioned there's an example that I can give you of partial payments and how that can affect the association. So sometimes you will get a check from a homeowner for partial payment, and that check will have a specific limiting instruction or restrictive endorsement on it, right? It will say something like, this is payment in full, or this is payment for assessments for 2024, or something to that effect that the homeowner has written on that check. Any statement that the homeowner has applied to that payment, that's what we call a limiting instruction or restrictive endorsement. Keep in mind, though, if you accept that check, it might equal payment in full of the account, even if that check was for less than what's due on the account, right? So you have to be very careful about accepting payments that have some sort of instruction on how the owner wants the association to apply that payment. And then also keep in mind that there are statutory requirements or instructions on how those payments are actually supposed to be applied. Now, there is also a situation where a homeowner may have been on a payment plan with the association directly, and they have defaulted on that payment plan. There are certain rules and requirements about whether or not the association has to actually accept those payments if the homeowner has defaulted on a payment plan. So let's get into that just a little bit. So first and foremost, I want to talk about the priority of payments statute. So you're probably all familiar with this. This is section 209.0063 of the property code. And it is very specific in how the association is supposed to apply their payments, right? So any payment that the association gets from a homeowner has to be applied to a delinquent assessment first, then to current assessments, then any sort of collection costs, attorney's fees, other attorney's fees, fines, and then any other amounts that are owed to the association. This application of payments or priority of payments statute is something that we also are bound by. So that means that if we get a payment, we apply the payments that we receive in the exact same way. Now, I mentioned earlier that if the homeowner was on a payment plan with either the association or one that they've entered into with the attorney, the association does not actually have to accept a payment or apply a payment in this priority if that owner has defaulted on a payment plan or alternative payment schedule. Also, though, keep in mind that fines can never be given priority, so it doesn't matter what happens, the association cannot apply payments to fines first. So in the scenario that I mentioned earlier, if a homeowner is making a payment of $2,000 on a tab that they have that's worth $10,000, the association has to make the decision about whether or not they actually want to apply these payments. And this is also given, perhaps the association does not have any sort of agreement with the homeowner. Do they apply these payments? Will the payment actually cover the assessments only? And then the only thing that's left on the account is interest or late fees or attorney's fees. A couple of, homeowners can be savvy in the sense that they know that if you cover the assessments, then each time they become delinquent and they only cover the assessments, then the likelihood of that file getting referred over to the attorney is less. Or if it is at the attorney's office, then the likelihood of a lawsuit being filed is less, because it's more difficult for us to substantiate a lawsuit to a court if there are no assessments that are due on the account. Now, there is no priority of payment statute in Section 82 that applies to condominiums. So our recommendation would be to adopt a priority of payment policy that kind of mirrors what the 209 language actually states. A lot of times, though, condominium governing documents will have their own priority of payment provisions. And so it's worth taking a look into the governing documents just to kind of see if there's anything in there already. But one of the pitfalls that we see here a lot is, accepting those partial payments, applying them when they probably shouldn't. Homeowners defaulting on defaulting on their payment agreements, and then, the association having to decide whether or not they're going to accept payments, whether or not they will reinstate that payment plan, that sort of thing. So these are just some things to keep in mind. Accepting partial payments can actually be pretty dangerous if there is quite a bit that's due on the account. So again, this is something that can be up to the board's discretion. But internally, we would probably never accept a partial payment unless the homeowner was on a payment agreement. All right, so now let's talk about bankruptcy, because I think this is one of the things that trips us up a lot. Even me, sometimes I get tripped up by this bankruptcy, but I think in general, one of the takeaways that I'm going to want you guys to have for this is that if you see a bankruptcy that's filed, you got to stop everything that you're doing, because there are some pretty strict laws that are in place with regard to bankruptcy. Now, a debtor can actually file bankruptcy at several different points in the collection process. One of the times that we see it happening most often is when they start getting these letters from either the association or from the attorney saying, you owe this amount of money, then they will file bankruptcy. But the time that we see it happen the most, I would say, is when a homeowner is posted for foreclosure. So the morning of foreclosure, we get a lot of bankruptcy notices because a homeowner knows that if they file bankruptcy and they notify us of it, then we cannot proceed forward with foreclosure, right? So there is a federal statute. It's basically an injunction that says that any act to create, perfect, or enforce any liens against property of the state, that basically has to stop. A debtor is enjoined from proceeding with that if a homeowner files bankruptcy. And that's what we refer to as a stay or an automatic stay, right? So who gets a stay when an owner files bankruptcy? most debtors will get a stay, and it's automatic. That means as soon as that filing happens, the stay automatically goes in place unless a bankruptcy was dismissed within a year of the current bankruptcy filing, or there are 2 or more bankruptcy cases filed and dismissed within the last year of the last dismissal. Now, there are some of these exceptions that are put in place to kind of protect debtors too, right? Because courts know that a lot of times these homeowners are filing bankruptcy one after the other, because they want to prevent any debtors from being able to try to collect against them. So the automatic stay provision is not totally consumer friendly. There are some protections for debtors as well. Now, the statute doesn't allow any sort of limit for how many times an owner can file bankruptcy, because like I said, homeowners they file one after the other sometimes. But there is a statute that was enacted in 2005, the Bankruptcy Abuse Prevention and Consumer Protection Act, that does provide some limitations, right? So it limits the imposition of the automatic stay depending on the debtor's bankruptcy filing history and the ability of a debtor to receive discharge of debts. So what this basically means is that a bankruptcy court is going to look at a debtor's filing history, and they're going to look at how many times they've either been discharged or dismissed of their debt, right? And the court will make a decision about whether or not this homeowner or this debtor in the situation is simply abusing the bankruptcy process, or if they have a legitimate claim. So that is something that we can kind of rely on. And we've seen this happen time and time again. I'll tell you, for example, we went through the collection process and got a judgment and ended up having to foreclose on a homeowner. The homeowner did not redeem the property during the redemption period. And so eventually it got to the stage where we had to seek an eviction. Well, the homeowner filed bankruptcy before we were actually able to evict. So that prevented the eviction process from going forward, right? That automatic stay went into place. And then the court had to step in and notice that this homeowner had filed bankruptcy so many times that the court eventually dismissed that bankruptcy, and we were able to proceed. But it does add a lot of time onto the process, because it does take time for the court to actually go into the bankruptcy filer's history and kind of, look at what's going on there. So this is just something to keep in mind, that the bankruptcy process is never something that's quick, but fortunately we have some pretty solid, of course, you guys probably know Mary, internally, that would continue to monitor and then intervene where necessary with the bankruptcy process. All right, so if you receive a notice that someone has filed bankruptcy, whether or not this matter is attorney status or you guys still have it internally, it's important to go ahead and notify the association's counsel immediately when you get that bankruptcy notice. Now, there are situations where a homeowner doesn't actually send you an actual notice of bankruptcy, but if you're talking to a homeowner over the phone, that homeowner needs to provide you with the case number and the date that they actually filed their petition, so that you can provide that to the association's attorney and we can go in and look up to make sure that there's actually a bankruptcy filing. Any court notices that you get, when you are actually notified by an actual paper notice that a bankruptcy has been filed, then you need to forward that to the association's counsel immediately. And then once the association's attorney is notified, no other notices need to be provided, except if there is a notice of debtor's intention to strip HOA lien or in some sort of objection to claim. So remember the name of that form: notice of debtor's intention to strip HOA lien or objection to claim. Also, under the statute, this notice carries a very short statutory deadline. So that means that we would only have 28 days from the date that it was filed to respond or file some sort of objection. So that means as soon as you get notice of this kind of filing, then you need to let the association's attorney know ASAP. Now, bankruptcy also there's a couple of other problems, in addition to the fact that the association cannot proceed with its processes, right, its collection process. You also have kind of an accounting issue that comes into play when we're dealing with bankruptcy. And there is a split of the account that needs to take place. So accounts that have been some sort of bankruptcy filing on them must be split at the bankruptcy petition date. So the petition date is going to be the date that the actual bankruptcy filing happens, right? And this is important because, just letting us know that there is some sort of bankruptcy going on. Splitting that account is really important too, because the account should stop any sort of automatic statements or any sort of automatic issuance of statements to a homeowner with things that say balance forwards or entries that say balance forward. You don't want to also issue any statements which include any pre-petition amounts on them. So that's why it's really important to note that bankruptcy petition date and make sure that the account is split. The issue is that this not only is this going to be a violation of the automatic stay, but it also violates other provisions of the bankruptcy code. And so we have to make sure that those accounts get split by the petition date. So it's going to be pre-petition amounts versus post-petition amounts. Make sure you keep that in mind. And if you have questions, reach out to the association's attorney. This is something that can get kind of complicated, so I would highly recommend reaching out to the association's attorney. So if there is any situation where the association and even the attorney violates the automatic stay, then it can become very costly. And really, all it could take to violate the stay is one demand for payment that could create a claim or give rise to a lawsuit, right? If there is some sort of automatically generated statement that I just mentioned before that goes out to the homeowner that has the wrong amounts on it, that has maybe those pre-petition amounts on it, that's actually something that we see happen the most often. And so immediately when you get a bankruptcy notice, you want to flip that switch in your accounting department that says, don't send out those automatically generated statements to this homeowner. Sometimes 209 letters can be just as dangerous as those automatically generated statements. So we want to be careful about sending those out as well. Any notice or demand letter that demands payment or threatens action can be a violation of the automatic stay. So we want to try to avoid that as much as possible. And then if you fail to report notice of a bankruptcy filing to counsel and there's a lawsuit going on and we continue doing things in that lawsuit, we, file a motion or schedule a hearing or something like that, that is also a violation of the automatic stay. So here are the pitfalls that you need to take note of when it comes to bankruptcy. These are things that you absolutely want to stay away from so you don't violate the automatic stay and don't cost the association any money. All right, so we did want to go into what the collection timeline internally looks like for RMWBH, and I'll do single family and then I'll do condominium. So let's kind of go over this just a little bit. On the first day that file gets referred to our firm, between days 2 and 7, we are setting up the account. We are conducting deed and bankruptcy searches. Obviously, that bankruptcy search, as I just mentioned, is very important. And then our setup team is also inputting the ledger that we get from you. So that's why it's really important that we have an account history and an expired 209 letter when you refer those accounts over to us. After we have gotten the account completely set up and there are assignments to our internal paralegals and attorneys, then we proceed forward with sending that Reg F letter that I was mentioning earlier. That's a requirement by the FDCPA. That notice, again, provides homeowners with 40 days to either remit payment or enter a payment plan. And then also remember that that provides instructions for the homeowner on how to dispute a debt if they're so inclined to do that. After the expiration of that notice, then we do what's called an NFC. The NFC is a nothing further certificate. It is a title search. We are making sure that the property has not changed owners, that there have been no liens filed. If there are liens filed, we take note of those as well. There are a lot of different things that can come up in the NFC, divorces, things of that nature. So that's the time during which we would review that search. And then finally, if we see any lien holder notices, or if there's a necessity for us to send a final demand letter, we will do that. If it's just a final demand letter, the homeowner has 30 days to remit payment. If it is a lien holder notice letter, remember earlier I mentioned that requirement statutorily is 61 days to remit payment. And then finally, if we have gotten no response from the homeowner after we have completed this timeline, then we will make a request to the board if we should file a lawsuit or not. And that may be one of the times where the board can actually go into their open board meeting and consider and vote on whether or not we're going to initiate foreclosure action. So there are 2 steps in this process where the board can make that decision. It can be before day 1, or it can be between days 90 and 120 when we have reached out to the board and said, hey, listen, we've gone through our entire internal process and we've gotten a response. Can we go ahead and proceed with our lawsuit? This is also a good time for the boards and management to kind of take a look at whether or not the homeowner has made any payments in the meantime, because that's going to change things significantly based on how much they paid, at what point they made that payment, and that sort of thing, right? So now let's take a look at what the process looks like for condominium associations. Again, we have that same kind of day 1 to day 8 sort of thing. The file gets referred. We will complete that setup, any deed searches and bankruptcy searches, and then input that ledger again. So this is why it's important for us to have an account history and an expired letter, right? We refer to these internally as 209 letters. Obviously, condominiums are governed by Section 82, but sending the same type of letter makes sense because it provides all of the information that's necessary for the homeowner. We will go ahead and send out that Reg F letter between days 3 and 8. Again, that's the same kind of notice requirements. That Regulation F letter is dictated by the FDCPA and not state law. So that notice period is going to be the same for each type of community that we're dealing with. We will also go ahead and complete that NFC. There are less chances that there's a lien holder with the condominium, but we never know. So that's why we go ahead and do that. We send our final demand letter. There is no requirement that we actually have to send out lien holder notice letters in the Chapter 82. So that final demand letter is going to provide 30 days to the owner to remit payment. And then we can, after that's all done and we have not gotten any response from a homeowner, then we can make a request to post the property for foreclosure. After we've made that request and we have posted it, we have gone through the process, the statutory requirements, notice, and so on and so forth, then we can go ahead and post that property for sale. Now, these are general timelines. Of course, there are some things that can change those, but generally this is what the internal process looks like for us. So I'm going to go ahead and give us our conclusion, and I see that there are a bunch of questions in the chat, and so I'll go and look at those and get through as many of them as I can. But just keep in mind with everything that we've talked about, there are so many different stages in the collection process where there can be a pitfall or some way we can get tripped up. And so knowing what the collection process actually looks like and knowing the statutory requirements is very, very important so that we hit all of those and don't leave anything out so that we can go ahead and go through the process without any issue. Because keeping in mind, if we don't pursue that collection process, it puts the association at risk for claims against it for waiver of their authority to enforce the restrictions. We might run into statute of limitations issues. With the bankruptcy I mentioned, there might be potential for a violation of the automatic stay. There are a lot of issues that we mentioned today, things that we want to avoid. So that's kind of, part of the reason why we provide this information so that we can avoid those things as much as we possibly can. But also make sure that you are relying on the law and subject matter experts like us to guide you through the collection process, because we don't know everything. None of us know everything. None of us are perfect. So we want to provide as much assistance as we possibly can. All right, so let's take some questions. I have about 10 minutes and I will get through as many as I can. So, there's a lot of questions. Okay, so the first question for certified mail 209 letters, if the owner was given notice and a reasonable opportunity to cure the same violation within the preceding 6 months, can we assume that such notice would have had to follow 209 in the initial notice within 6 months ago? I am confused by that question, but if it's reading the way I think it is that if you've already sent a homeowner a 209 notice within the preceding 6 months, I would just ensure that first 209 notice actually is related to the same violation. And the answer is you don't have to send another one. The statute is pretty clear that within 6 months, you don't have to send more than once. Now, outside of 6 months, I actually absolutely would recommend sending another one, right? All right, when an owner requests a hearing for ACC violation and fines, is the hearing an open board meeting where all owners are invited to attend? So let's kind of go back to the slide that we had before that talks about all of the requirements for 209.0051, things that have to be done during an open board meeting. This is ACC appeals is one of those things. So that is a requirement. It should be done during an open board meeting, but my recommendation to preserve the privacy of the homeowner would be to get the homeowner, ask them to agree to have that ACC appeal hearing either during the executive session or perhaps just slightly before the open board meeting starts, so that you are not putting all of their business about their violation and giving them the opportunity to speak freely. Can the association send reminder letters to delinquent accounts that are not the attorney if we do it for all and treat all the same? Sure. So the association should have a collection policy. The collection policy should set forth what sort of notices that will be sent out. Generally, the ones that we create will say that the association can or may send out courtesy notices. I would not send out a reminder after you send out a 209 notice, though, because it already provides a amount of time that the homeowner needs to respond, and you don't want to confuse them. So if you're sending out a notice that has some sort of cure period in there, go ahead and let that cure period expire so the homeowner doesn't get confused, that they might think that the time would restart based on the reminder letter that you sent. Can a 209 letter and other delinquency letters be sent to property managers of units? If so, do we need any documents on file from the owner to do this? So the property code is pretty clear about who those letters need to be sent to. They need to be sent to property owners. And if the owner has provided the association with contact information for someone else, then the association is within its rights to actually send the notice to whoever the owner has provided, if it's a manager or whatever. But the owner also probably needs to get that notice as well. So if you have a situation where the association has, the records have been updated with a property manager or a tenant or something like that, you need to still kind of go look at the HCAD or whatever the CAD is maybe, and make sure you're sending that letter to the property owner. Would it be advisable to routinely include a hearing item on the posted board meeting agenda for executive session in case an owner chooses to appear or provide notices in advance? You can do that, Jose, but there are a lot of times when there is no request for a hearing. I think those are not as frequent as you might think. And so if you want to have a standing item on there, you certainly can do that, but it's not required. Are late fees and interest required to stop during waiting periods after notice? Yes. So what I would recommend is, since the late fees are generally accrue monthly, if a homeowner is responding within that time period that you've given them to cure from the letter, then I would not charge them the interest or the late fees during that time period. But you need to look at what your governing documents say. If the governing documents say that interest and late fees are going to continue to accrue, you should do that. Go ahead and post it the way it's supposed to. But you could, the board could be more amenable to maybe waiving those late fees and interest if the homeowner responds and the time period is going from month to month, if that makes sense. How does the collection process differ during developer control period? That really will be up to whatever your governing documents say. So if the developer has adopted a collection policy, then we can go with that collection policy. And if there are certain requirements or provisions that are in the governing documents, then I would recommend going according to that. But the developer is within its rights to adopt a collection policy if it would like to. Another question is, when you say enforcement actions for open session meetings, what step of enforcement do you mean that would need to be voted on in an open meeting? Would this include initial enforcement? Is it only when we would vote to turn over the association's attorney? Okay, Eve, this is what I was mentioning, right? So this can be a decision that the board makes, right? Initiation of foreclosure action can actually mean when you are beginning the process with the attorney. So the referral period over to the attorney, or when the attorney reaches back out and says, our collection procedure, the one that I mentioned to you earlier, has not been successful. The homeowner hasn't responded to any of our letters. Can we proceed with a lawsuit? I would recommend go ahead and doing it at the beginning when you're referring it over and just kind of getting it out of the way. Regardless, we're still going to reach out to get approval from the association to file the lawsuit, right? But if you want to include it in the meeting minutes at the referral period, then that's perfectly fine. Okay, this is a pretty long question. If the board votes on the minutes list below, does that cover them in reference to what you're referring to? So the board voted on deed restriction violation matters and approved levying fines on owners who have violated. Yeah, so this statement that you've made, Mary, and if you guys want to go check the chat, because I won't read all of it so we can get to the other questions, but this is a solid statement about what the board has done with regards to approval of initiation of foreclosure actions, right? It doesn't have to be this long, because keep in mind, meeting minutes don't need to be very long. The agenda doesn't need to be very long. Meeting minutes are something that can be produced in discovery, so you don't want them to be paragraphs long, but something to that effect work. Action between meetings, what are the Texas Property Code limitations? Michelle, reach out to me and I'll get to you a response to that, because I want to make sure that I answer questions about the collections process right now, if we don't mind. Brad, if the association decides to take properties to small claims court instead of sending them to attorney and are still following 209 by sending the certified 209 letter and offering the hearing, is that a possibility? Yeah, the association can do that as long as you follow the 209 process. How you file your lawsuit is really is going to be up to the association ultimately, right? Of course, the attorney is going to make certain recommendations, but I personally wouldn't recommend going to small claims court. There's a bunch of it. First of all, it takes a lot of time and resources from the association, from someone to go down there and sit through those hearings. But I would also just simply recommend for the association to let their attorney do this. And generally, we file these in district court because the amount of controversy fits within the district courts. So this can be done, but I wouldn't recommend it. Beth says, we add send account blank to attorney for collection actions up to and including lawsuit in the minutes. Then when we get an authorization, is it still necessary to minute the lawsuit authorization separately for that account later on? Beth, the answer to that question is no, you don't have to, but it is a good practice to go ahead and make sure that that's included in your minutes. So if a lawsuit comes up and then there's a counterclaim filed or some discovery or something like that, we would be able to show the opposing attorney that not only did the association vote on it once, but they voted on it twice. We will provide the slides, and then I think that this is going to be posted on YouTube for you guys to be able to see. Floyd said, I mentioned earlier that lawyers want to see meeting minutes about approvals for lawsuit, but under developer control, 209 doesn't require that they vote for that. Right, the association will only provide documents that it's required to provide. So if an attorney makes a request of us in discovery that they are something that they're not entitled to, then we won't provide it, right? So we'll go and look at the statute and make sure that they are able to request those documents. If not, we will lodge an objection. If an owner says they don't know for sure who owns the property, oh yeah, we can, that's easy for us to find out, right? We can go to the real property records and figure out whose name is on the deed. On the balance forward, if there's a homeowner who is in a payment plan with the attorney after bankruptcy, is it okay to send the statement with their past due balance? I would recommend against doing that, mainly because there might still be some issues and we don't know whether or not that bankruptcy has been discharged or dismissed. And so it would be a good idea to consult with the association's attorney before you send that statement with their past due balance on it, so that we can make sure what has come of the bankruptcy filing, or if the bankruptcy is still ongoing. What if the owner states they're filing for bankruptcy, but they actually didn't? That's the reason why we asked for the case number and the date that they filed the petition, or make them send you the actual notice, because if they can't prove that they filed bankruptcy, then you might not be able to take them seriously. We can always go and check the bankruptcy court records to see if there's been any recent filings by that homeowner. But those bankruptcy court filings, it's better if we actually have the case number so we can make sure it's the right homeowner, because sometimes people's names are similar and it's difficult for us to figure out who exactly has filed that bankruptcy. If the owner is not paying the post-petition amount, should we let the association attorney handle that? Yes, you should. If someone claims that they have a lien on the property, but they can't provide proof, then if they can't provide proof, then they don't have it. When a bankruptcy court case is dismissed, what is considered a reasonable length for a payment plan if the association's payment plan policy states that the max is 18 months? If the policy states max of 18 months, then that's what you should go with. But I would also just make sure we get a chance to review what that bankruptcy actually looked like. Dismissed is different than discharged, right? When it's dismissed, it's as if the bankruptcy never actually happened. I think that the association might be able to go outside of 18 months at its discretion, but I would look at the payment policy plan to see if it has the authority to actually do that. How do condos within an HOA get handled if the condo is delinquent on management fees and HOA assessments as well, which is the superior debt? Basically, it depends on what the governing documents say, right? So the association's declaration will say that there might, if there's a superior lien holder that's evidenced by a deed of trust, then you look at when those deed of trust were filed in the real property records, and then that can help you. So look at the filing date. That will actually help. If you need more information about that, Tom, reach out and I'll answer more questions for you. Do electronic return receipts fulfill the requirement for certified letters? As long as it's a USPS certified letter tracking information, then yes, it does. All right, so I've hit 12:30 and there are still quite a few more questions. If you guys would like for me to answer your questions, go ahead and send me an email and I'm happy to do that for you. But I appreciate you guys so much for joining us today. I know this was a shorter topic, so we got a chance to get to a couple more questions, but hopefully this was helpful. And as Andre tells you, the PowerPoint will be available. He'll email it out to all of the attendees. And then also this presentation will give you CE credits. So if you want to get your CE certification, let us know and we'll provide that to you. All right, thank you guys. Have a great rest of your day.